Assalamualaikum warahmatullahi wabarakatuh. First of all, let me introduce myself. My name is Eva Nurhayati. My student number is 80. I'm a college student of Agribisnis study program, Agriculture Faculty, University of Trunojoyo, Madura. In this video, I will explain about bankruptcy law and its case studies. The legal basis for bankruptcy or PKPU, namely Law Number 37, years 2004 concerning bankruptcy and postponement of debt payment obligation. Not only that, the regulation regarding bankruptcy in Indonesia are also available. Law Number 40, years 2007 concerning limited liability companies. Law Number 4, years 1996 concerning mortgages, and Law Number 42, 1992 about the fiducia gerundio. Bankruptcy is general confiscation of all assets of a bankrupt debtor whose management and settlement is carried out by the curator under the supervision of the supervisory judge. In Law Number 37 of 2004 concerning bankruptcy and postponement of debt payment obligation, there are important principles in the application of bankruptcy, namely first, principle of balance, 2, second, principle of business continuity, third, principle of justice, and fourth, the principle of integration. The purpose of the bankruptcy law is to distribute the assets of the debtor to his creditors by confiscating the debtor's assets, and the assets of the debtor to be distributed to creditors in accordance with their rights, and to prevent the debtor from committing acts that could harm the interests of the creditors. Then the bankruptcy process. Process or step in the bankruptcy can be seen in the table beside. In the process, there are several steps and these steps need to be done. Steps in the bankruptcy process. The first is the petition for bankruptcy. Then a bankruptcy decision is obtained for the supervisory judge and the curator. After that, the announcement of bankruptcy, then there is a reconciliation proposal. If the proposal is approved for approval, then the bankruptcy will continue. At the end and the last is the distribution of settlement result. However, if the proposal is not approved or there is a no settlement of the debtor in a state of insolvency, then proceed to the process of clearing the bankruptcy estate and finally sharing the settlement proceeds. The terms of the application for bankruptcy. The requirements for filling an application for a bankruptcy statement against debtors can be seen in Article 2, Paragraph 1 of the Bankruptcy Law, which reads, "Debtors who have two or more creditors and do not pay off at least one debt that has elapsed in time believed, declared as validated by a court's decision on the right to the petition one or more creditors." So it can be concluded that the requirements for bankruptcy application are the existence of a debtor and the presence of two or more creditors. Okay, then I will discuss case studies from journals that discuss bankruptcy law with a journal entitled Corporate Liability in Bankruptcy Based on the Principle of Proportionality, case study on PT Asuransi Jiwa Bumi Asijaya. Bumi Asijaya is one of the local life insurance companies in Indonesia. Founded on the 10th of June 1967, entering its fifth decade. Bumi Asijaya has an extensive marketing network spread throughout Indonesia, with the support of 286 marketing offices. Bumi Asijaya has more than 6,000 professional workers. To fulfill its dream as a multinational company, Bumi Asijaya has expanded its business by establishing several subsidiaries that are engaged in various fields. The business activities of the Bumi Asijaya subsidiary have also spread throughout Indonesia. Initially, PT Asuransi Jiwa Bumi Asijaya experienced a decrease in its financial health ratio, which violated the provisions of Article 2, Paragraph 1 of the Decree of the Ministry of Finance regarding the financial health of insurance companies and reinsurance companies. However, after 1 year running, PT Asuransi Jiwa Bumi Asijaya was still unable to meet its solvency level. Finally, BAPEPAMLK issued a sanction to restrict business activities. Then, after receiving the audit result report from 2012 to 2013, the total equity of PT Asuransi Jiwa Bumi Asijaya also changed to minus. After the supervision and regulation moved to the OJK in 2013, the OJK withdrew the business license of PT Asuransi Jiwa Bumi Asijaya for the above reason. The purpose of the revocation is to protect the interests of policyholders and the public and to prevent public losses that will arise later as a result of violation of laws and regulations in the insurance sectors. Then, in May to July 2016, the Director of Asuransi Jiwa Bumi Asijaya and the Commissioner of PT Asuransi Jiwa Bumi Asijaya made withdrawals by way to overbooking and or case withdrawals from the account of PT Asuransi Jiwa Bumi Asijaya without permission and the knowledge of the curator. These assets are the obligation of PT Asuransi Jiwa Bumi Asijaya to pay obligation to customers because the money is the customer's money. The policyholder in the case acts as a client or creditor of PT Asuransi Jiwa Bumi Asijaya. This required the asuransi company PT Asuransi Jiwa Bumi Asijaya to immediately carry out its responsibility, namely the obligation to pay debt to policyholders. This accountability must be carried out because before the bankruptcy occurred, the policyholder and the insurance company PT Asuransi Jiwa Bumi Asijaya had entered into the agreement of outlined in the insurance policy. Insurance policy is proof of insurance coverage agreement. The liability of the insurance company to policyholders is based on the principle of liability on the basis of error. In this case, the insurance company has committed negligence among others due to the condition of financial health which has decreased continuously. There is a criminal act of money laundering from company organs and curators until finally the bankruptcy occurs which cause loss to the parties. Therefore, PT Asuransi Jiwa Bumi Asijaya in this bankruptcy has an obligation to be responsible to the injured party up to personal assets. In relation to the principle of proportionality, this must be done by dividing the rights and obligations between the parties according to their respective portion, namely by the returning the premiums that have been paid of policyholders. However, in the end, it can be seen that the liability of the PT Asuransi Jiwa Bumi Asijaya to policyholders as preferred creditors has not been carried out in the accordance with the principle of proportionality. Okay, maybe that's all I can say. Thank you very much for your nice attention, and last I say, wassalamualaikum warahmatullahi wabarakatuh.